Welcome to the Gladiator 2021 Championship round. My name is Justin Bernstein. I'm thrilled to say that we have two outstanding finalists as attorneys, two outstanding finalists as witnesses. We started with 60 competitors and we are down to the top 4. We are thrilled to have this great final round, and I'm going to welcome on screen our judges for this afternoon. We have an all-star panel of judges. We have Sue Johnson, Director of Forensics at Patrick Henry College, 2 teams in the national top 10 this year. Stephen Johnson, the former college one-on-one national champion, now a law student at UCLA and nationally competitive there as well. I like it. Glenn Halvan-Neubauer, the Director of Furman's mock trial program and the host of Top Mock, our sponsor for this event, and a professor in political science at Furman. Their team has qualified for the national championship literally dozens of times. We have Frankfurt Johnson, volunteer at all of the top competitions. And while I don't want to pick our favorite volunteer, it's Frankfurt. We've got Tom Shearer, who is the head coach of Stanford's mock trial team, another top 10 national program this year, like every year. He is the only coach to win this tournament twice. We have Grace Grimes, a law student at Drexel University in Philadelphia. Grace is new to mock trial. It's her first year, but you wouldn't know it. She went to 3 competitions. Her worst result, national quarterfinalist. She's extraordinary. We have Phil Pasquarello, where Stephen won the college one-on-one national championship. Phil is the winner of the law school one-on-one national championship from 2018. He is the Top Gun champ and the trial competition director at Drexel. We have Elena Young, an all-American competitor from UC Santa Barbara and a runner-up at this very event. We have Melissa Watt, one of the, actually the only coach to coach 3 different colleges to the national championship tournament. The only one. It's a good bit of trivia. She is now the national tournament director for the American Mock Trial Association. And finally, we have Jess Faulkenstein. Jess is, of course, the key witness in this case. She played the victim in the infamous video you may see during this round. She's a lawyer in Philadelphia and a former law school national champion. Thank you to our fantastic judging panel. I'm going to have you turn off your videos and we are going to start our trial, our championship round. Can I get appearances, please, starting with the plaintiff? You can both join on screen.
Good afternoon, Your Honor. My name is William Mueller, and today I'm joined by my co-counsel, Julian McGaugh.
Good afternoon, Your Honor.
Good afternoon.
Together, we represent the plaintiff, Ethel Marks.
Appearances from the defense, Your Honor.
Please.
Good afternoon, Your Honor. My name is Connor Wright on behalf of the defense. I'm joined today by my second chair, Ethan Wright.
Good afternoon, Your Honor.
Good afternoon. All right. Any housekeeping issues from the plaintiff?
Yes, Your Honor. Firstly, we move to invoke Rules 603 and 615, which call for the constructive sequestration and swearing in of witnesses.
That's granted.
Secondly, Your Honor, we'd like to draw the court's attention to Stipulation 11. Stipulation 11 says that exhibits, excuse me, Mr. McGaugh, could you take that down? Instead, Your Honor, we'd like to ask for your preferences on screen sharing. When we put up an exhibit, would you like us to ask permission first, or can we just let Your Honor know?
If it's an exhibit that is not yet in evidence, it should be admitted before you show it to the jury. That said, if there's something you want to show during opening statement that you have a good faith belief will be admitted, you can ask permission to do so. As far as things that are demonstrative evidence, you're welcome to share that. And if opposing counsel has an objection, they'll be able to raise it. Does that answer the question?
Yes, Your Honor.
Great.
And lastly, we do have one exhibit that we'd like to use in opening statement. It's Exhibit 2. It's a photo of the deceased in today's case, and we have a good faith belief that it's going to be introduced into evidence on our very first witness.
Defense counsel, any objections to the use of Exhibit 2 in opening statement?
No objections, Your Honor.
Are there any exhibits you wish to display in opening statement?
Yes, Your Honor. Exhibits 8 and 9, photographs of Sonny's rooftop bar.
Any objections, Mr. Mueller?
No objection.
Okay, all of those are going to be permitted during opening statement. Anything else, Mr. Mueller?
We have a couple evidentiary arguments, but no housekeeping matters.
All right, any housekeeping matters for the defense?
Yes, Your Honor, we'd like to invite the court's attention to Rule 9D. All witnesses have a virtual notebook of all exhibits.
Thank you. All right, let's turn to those substantive matters. Plaintiff?
Yes, Your Honor. Firstly, we move to enter Exhibit 1 into evidence. It's a plea agreement that the defendant, Sonny's Rooftop Bar, signed.
Any objections?
Yes, Your Honor, we do have multiple objections to this under 404 and 403.
Okay, let's start with your 404 argument.
Yes, Your Honor, the plaintiff is offering this plea agreement for propensity purposes. It's an instance of conduct that's being offered to show a character trait of negligence, that servers from Sonny's Bar served alcohol to a minor in the past, and that they did it again on March 24th. And this isn't going to fall under any character exceptions.
Mr. Mueller?
Your Honor, for the 404 argument, we're actually not offering this for propensity. It's been stipulated by both parties in this case that Jessica Marks is a minor. Was a minor, on March 24th, 2019. So we're not offering this to show that because they served a minor once, they did it again, since that's already been agreed to.
Response?
Yes, Your Honor, it's still the defense's position that they're offering this for propensity purposes on behalf of Sonny's Bar, but our 403 gets more into that stipulation.
Okay.
Your Honor, we believe this is going to mislead the jury. The bartender in this plea agreement, while they were working that night, at no point did any witness in this case say that that person ever served alcohol to Jessica Marks. We believe it's going to mislead the jury, and we have an objection under 403.
Mr. Mueller?
Your Honor, the defendant in today's case is Sonny's Rooftop Bar. One of the employees that signed this plea agreement was Frankfurt Johnson. He was working back then when they served the minor, and he was working in this case as well.
May I respond to that, Your Honor?
Yes.
The problem is that that specific instance from the plea agreement, well, yes, the owner of the bar had to sign the plea agreement. He wasn't the person that the plea agreement was specifically directed to. It was Frankfurt Johnson that served alcohol to that minor, and that is what caused that person's injuries.
Okay, I'm going to exclude Exhibit 1. Plaintiff, do you have an additional argument? Additional motion?
Yes, Your Honor. We move to enter Exhibit 23.
Explain.
It's a report made by Sammy Gaskins, the responding officer on the scene of the crash on March 24th, 2019. Falls under 803.8 as a public record.
Mr. Wright?
Yes, Your Honor, we believe there is some hearsay within hearsay in Exhibit 23, as well as there isn't foundation to establish this as a business record.
Do you want to go into more detail on the hearsay within hearsay?
Yes, Your Honor. In this exhibit, it says there are statements from Frankfurt Johnson and from Morgan Levin, and that's hearsay within hearsay. Those specific statements we could get on the screen if Your Honor would like.
That's not necessary yet. Is this the same Frankfurt Johnson we were talking about with Exhibit 1?
Yes, Your Honor.
Mr. Mueller?
Your Honor, we'd be happy to constructively redact all hearsay statements in the document. We actually want to use that police report for other information that's not hearsay within hearsay.
Okay, so you're talking about the officer's statements rather than statements made to the officer?
Yes, Your Honor.
Defense counsel, would you be amenable to that?
Yes, Your Honor.
Great. It sounds like we have an agreement, and we'll put that on the record. Anything else from the parties before we turn to opening statements?
Not from the
Nothing
plaintiff.
from the defense, Your Honor.
Great. I'm going to have my video off for most of the trial, so our recording gets to focus on you all. So I will turn it over to you, plaintiff. You can open.
Yes, Your Honor. May it please the court, members of the jury. They knew she was drunk but they kept serving drinks. It's a Sunday night back in March of 2019 at a bar over in West Los Angeles. A young woman stumbles out of the bar and into the parking lot, barely able to walk in a straight line. For the last 3 hours, she'd been served drink after drink after drink by the defendant, Sonny's rooftop bar. She's drunk. She gets into her car, turns onto the highway, but within minutes, car's at the bottom of a ravine. She's dead. Members of the jury, the woman in this photo is the woman that died that night, Jessica Marks. Ms. Marks' death was a tragedy. She was only 19. She had her whole life ahead of her. But what's most tragic about what happened to Ms. Marks is that it could have been prevented if not for the actions of Sonny's rooftop bar. Because the evidence will show that they knew she was drunk, that they kept serving her drinks, and that caused her to crash. That's why we brought a claim of wrongful death against the defendant. Now, we have the burden of proof. We have to prove by a preponderance of the evidence, meaning more likely than not, that the defendant served Jessica Marks when she was obviously intoxicated, and that their decision to serve her played a substantial role in causing her death. We're going to meet our burden. We're going to meet our burden by proving 3 simple facts. Let's take them one at a time. First, Jessica Marks was intoxicated at the bar. We're going to call someone named Morgan Levin to the stand. She was a friend of Jessica's and she was with her that night. She'll tell you that the whole time they were at the bar, she had all the classic signs of intoxication. Bloodshot eyes, slurred speech. She was stumbling around. But you won't just have to take her word for it. We're going to show you a video from that night. A video of Jessica Marks taken and a video where you'll see she is obviously intoxicated. Which brings us to fact number 2. The defendant saw that she was intoxicated. For this, we're going to ask you to listen to the bartender's own words. Towards the end of the night, as Ms. Marks had more and more drinks, and as her intoxication became more and more obvious, the bartenders acknowledged it. They looked at her and said, "We might need to cut this one off." But they didn't. And that brings us to fact number 3. Despite knowing that Jessica Marks was drunk, the defendant kept serving drinks. The evidence will show that even after they saw how she was acting, even though they admitted that they needed to cut her off, even though they knew she was drunk, they kept serving drinks. It's as simple as that. That's why at the end of today's trial, I'm going to come before you and ask you to find Sonny's rooftop bar liable. Thank you.
Thank you, counsel. Defense?
Yes, Your Honor. Sonny's rooftop bar only saw what Jessica wanted them to see. It's March 24th, 2019, just before midnight. Jessica Marks is standing in a parking lot. On one hand is her rental car, and on the other is an Uber. Her friend is called to take them home. But Jessica insists on driving. She tells her friend, "I've gotten pretty good at driving after a big night." She takes the keys out of her purse and with them she carries her life. Members of the jury, when a young person is taken from us, it's natural to want answers. Today, the plaintiff alleges that it's my client, Sonny's Rooftop Bar, that's responsible for Jessica Marks's death. And when they made that claim, they took on a burden to prove to each and every one of you, by a preponderance of the evidence, Sonny's Rooftop Bar served alcohol to an obviously intoxicated minor. Made the conscious decision to continue to serve her. That those drinks caused her death. The plaintiff, they'll fail to meet their burden because Sonny's staff only ever saw what Jessica wanted them to see. And when the plaintiff got up here just a second ago, they didn't tell you anything about the week leading up to March 24th. We will. You'll learn that Sonny's was actually the 10th place Jessica had successfully used her fake ID. It was the 6th place that week that she had driven home after drinking at a bar past her legal limit. That's a fact the plaintiff doesn't want you to know because it poses a problem for the plaintiff's case. Jessica Marks had gotten pretty good at driving and drinking. Jessica had gotten pretty good at fooling bartenders throughout LA. But not only that, you'll learn how Sonny's Bar was staffed that night. Mr. Wright, can we get Exhibit 8 and 9? You'll learn that on the night of Jessica's death, there was just one person serving those tables at the bar. The owner, Sonny Mehta. We'll show you that layout of the bar, 2 levels where Miss Mehta had to take the order from upstairs, get the drink from downstairs, and then go back upstairs to deliver the order, not just for Jessica Marks, but for 10 to 12 other people that night. Members of the jury, no one today is going to dispute how tragic the loss of Jessica Marks was. Her death was truly a tragedy. But when you took your oaths as jurors, you took an oath to separate sympathy from liability. That's why at the end of this trial, we're going to ask you to find Sonny's Bar not liable. Because Sonny's Bar only saw what Jessica wanted them to see. Thank you.
Thank you, counsel. Plaintiff, please call your first witness.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand.
You can proceed.
Thank you, Your Honor. Good afternoon, Ms. Levin.
Good afternoon.
Please introduce yourself to the members of the jury.
My name is Morgan Levin.
What do you do for a living?
Well, currently I'm a full-time student at UCLA.
What do you study?
Biology. I'm in my senior year.
Ms. Levin, could you open your exhibit book to Exhibit 2?
Of course.
Ms. McGough, we could take that down for now. Do you have Exhibit 2 in front of you?
I do, yes.
What is it?
That's Jessica at our high school graduation.
The plaintiff offers Exhibit 2.
No objection, Your Honor.
Admitted.
Mr. McGough, can we get that on the screen? Ms. Levin, how did you know Miss Marks?
Well, Jessica and I met back in middle school in 2013. We were inseparable ever since then. We did everything together. She was there for my first boyfriend, when we took the SATs together, when we got our driver's licenses. She was there for all of it.
Ma'am, when did you last see Jessica Marks?
I last saw her on March 24th, 2019.
What happened that day?
Well, that night, we had both gone to a bar, and As Jessica was driving home, I was in the Uber right behind her, and I was on my phone, and I looked up and her car was swerving, and I thought she would be able to fix it, but just kept going and going, and suddenly it fell into a ravine.
Did Miss Marks make it?
No, she didn't.
I'm sorry for your loss, Miss Levin. If it's all right, I want to talk more about what happened on March 24th, 2019. When did you first see Miss Marks that night?
At around 6 p.m., she came to pick me up, and we went to her Airbnb.
Did you and Miss Marks have any plans for that evening?
We did. We planned to make a pit stop at our Airbnb and then go to a bar, Sunny's Rooftop Bar.
Did you end up going to Sunny's Rooftop Bar?
Yes, we did. We got there at around 9 p.m. that night.
Do you remember what time you left?
At around 12, we stayed there for around 3 hours.
Miss Levin, from 9 to 12 that night, who served you?
Sunny Mehta, the owner of the bar.
Did either you or Miss Marks order drinks from Mr. Mehta?
Yes, both of us ordered a few.
Miss Levin, could you open your exhibit book to Exhibit 17?
Yes, of course.
Miss Levin, what is Exhibit 17?
It's the receipt from that night. It has all of our drinks and the food we ordered.
Does it look fair and accurate?
Yes, it does.
The plaintiff offers Exhibit 17.
No objections, Your Honor.
17 is admitted.
Mr. McGough, can we get Exhibit 17? Thank you. Just one moment, Your Honor. Ms. Levin, how many of the drinks on this receipt did you order?
Well, we ordered a bottle of wine, and I had one glass of that. And then I had a can of beer and also one green tea shot that night.
Were you there with Miss Marks when she ordered?
Yes, I was.
What drinks did she order?
Well, she had a couple glasses of wine to drink, I think around 3 from the bottle of wine, then the 3 White Claw cans and a beer and also a green tea shot.
I want to talk about how Miss Marks was acting after having those drinks. Could you open your exhibit book to Exhibit 10?
Yes, I can.
What is Exhibit 10?
Exhibit 10 is a video I took of Jessica that night, of her behavior.
The plaintiff offers Exhibit 10.
Yes, Your Honor. Objections 403.
Can you explain the 403 objection?
Yes, Your Honor. As we're going to see in Exhibit 10, that video, Jessica Marks is acting in a particular way. Opposing counsel isn't going to be able to tie that behavior to what Sunny's bar saw that night. Therefore, it's going to mislead the jury into thinking that she acted that way the entire night when Sunny's bar never saw it.
Mr. Mueller?
Yes, Your Honor. Under Rule 403, in order for evidence to be excluded, the risk of prejudice or misleading the jury in this case has to substantially outweigh the probative value. But that's not the case here. This is a video of how Jessica Marks was acting at the defendant's bar. Your Honor, this case is about how Ms. Marks was acting at the defendant's bar. It's probative.
How do you respond, though, to defense's concern that we haven't heard foundation, and they're concerned that you may not be able to lay foundation, that anybody employed by the defendant saw Ms. Marks while she was behaving that way?
Your Honor, whether or not there were employees that saw this particular video, it's still probative and important for the jury to see, as it's a depiction of how Ms. Marks was acting at the bar.
Last word, defense?
Yes, Your Honor. It's a problem for the plaintiff because if they can't link that behavior to what Sunny's bar saw, then they can't prove their case today. They have to show that Sunny's bar saw that Jessica was acting that way and then served her more alcohol under the Dram Shop Act.
Okay. I think this is a classic situation of weight, not admissibility. I'm going to allow the video. Exhibit 10 will be admitted, and you're welcome to cross-examine. And of course, your witness can testify about what she did or didn't see. So 10
Yes,
is
Your Honor.
Yep.
Could we get Exhibit 10? And can you play that for the members of the jury?
everyone. Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Miss Levin, was Jessica acting like that just in that video or throughout the whole night?
She was acting like that throughout the whole night, being a little loud, slurring her words, not really making much sense.
Miss Levin, do you remember any specific instances where Miss Marks interacted with the bartenders?
Yes, I do. There was actually two. One time, Sonny came up to the table to serve us a drink, and he said, this one better not be driving home. And one time, Jessica was walking down the stairs and she stumbled into Sonny, and they said, we need to cut this one off.
Miss Levin, did they cut Jessica off?
No, they didn't. She ended that night by receiving another green tea shot.
Thank you, Miss Levin. Your Honor, I have no further questions at this time.
Cross?
Yes, Your Honor. Good afternoon, Ms. Levin.
Good afternoon.
You know the plaintiff in this case, Jessica's mother, Ethel Marks, right?
Yes, I do.
After Jessica's death, Mrs. Marks, she threatened to sue you. Isn't that true?
Yes, she did. Her daughter had just died. Her emotions may have been all over the place.
Well, instead of suing you, now Mrs. Marks has called you to testify against Sonny's Rooftop Bar, right?
Yes, she wanted me to talk about what happened that night.
Ms. Levin, I want to talk about what happened that week. Now, that week that Jessica Marks visited you, you recall how many different bars you and Jessica went to?
Yes, I do. We went to a few different bars.
You said a few different bars. You went to 8 different bars. Isn't that true?
Yes, that's correct.
And from those bars, Jessica Marks drove from 5 of them. Isn't that right?
Yes, that's correct.
You're aware that if you're acting intoxicated at a bar, you're likely to be asked to leave. Isn't that right?
Yes, you may be asked to leave.
So in the presence of someone like Miss Mehta, you didn't want to come across as intoxicated, right?
Well, maybe, yes.
So let's talk about how you did appear that night. Your Honor, this time my second chair is going to be displaying Exhibit 26 constructively outside the presence of the jury for any objections. Your Honor, we move those portions of this exhibit into evidence.
Any objections?
No objections to those portions, Your Honor.
Okay, you can read them into evidence, or we can have them constructively in. It's your choice.
Yes, Your Honor. Let's have those first 2 constructively in, but Mr. Wright, can we get that last one on the screen? Question, were you concerned about Jessica getting behind the wheel? Answer, she was in better shape than her friend. Her friend could barely walk in a straight line to the Uber. A question, how was she walking? Answer, fine,
Objection,
I
Your Honor.
guess.
Lack of foundation.
Your Honor, may I respond?
Yes?
These portions are already in evidence.
May I respond, Your Honor?
That's my understanding too. Go ahead.
Yes, Your Honor. We agreed to allow those portions of the document into evidence. However, those haven't been read onto the record or to the members of the jury. So there's a lack of foundation as to how this witness would know how she was walking and whether or not he was concerned about her getting behind the wheel.
May I respond to that?
No, the objection's overruled.
A question, how was she walking? Answer, fine, I guess. I don't really remember. I just remember her friend was wobbling like she'd been in the ring with a boxer. Now, I want to talk about how you were acting that night. Is your testimony you weren't slurring your words, right?
Yes, that's correct.
Your testimony you weren't walking the way that deposition just described, right? You weren't walking like you'd been in the ring with a boxer, true?
Yes, that's correct. I had a little to drink, but I was just a little buzzed.
Let's talk about your interactions with Miss Maida. Each time Miss Maida came to your table, she was there for less than a minute, right?
Yes, 30 seconds to a minute, she would talk to Jessica and I.
During these instances, her attention was divided between you and Jessica. Isn't that true?
Yes, I guess you could say that.
You remember there were other tables at the bar that night that Miss Maida was serving.
Yes, that's correct.
On direct exam, you showed us a video of Miss Marks. You never showed that video to Miss Maida, did you?
No, I didn't.
In fact, you never showed that video to any of the bar staff that night.
No, I didn't.
You don't have any videos of how Miss Marks was acting when Sunny Meadow was around, do you?
No, I don't.
You can't remember a single specific instance where Miss Marks slurred her words in front of Miss Meadow.
No, I can't, but I do remember the bartender saying that we needed to cut her off.
Well, that wasn't my question. I asked you if you could remember a specific instance where Miss Marks slurred her words in front of Miss Meadow, and you can't, right?
That's correct.
You also talked about that receipt, Exhibit 17. Mr. Wright, can we get Exhibit 17 on screen? Miss Maida, that's the receipt, and that's you filling in the total, right?
Yes, that's correct.
That's the math error you made on the gratuity. True?
Yes, that's correct. It'd been a long night.
Let's talk about what happened when you left the bar. After you paid that bill, you and Jessica walked outside the bar, right?
Yes, we did.
No one from the bar was with you when you went outside. True?
That's correct. Yes.
And Jessica, she didn't stumble into the parking lot, did she?
No, she didn't. Not that I can recall.
She didn't fall down when she was walking out of the bar?
No, she didn't.
Thank you, Ms. Levin. And no further questions, Your Honor.
Anything further from the plaintiff?
No redirect, Your Honor. We'd ask that Ms. Levin be allowed to step down.
Thank you, Ms. Levin. You may step down. Any additional evidence from the plaintiff?
Yes, Your Honor. Before we close our case in chief, we'd like to read a few portions of Exhibit 23 that was admitted prior to trial.
Any objections?
No objections as long as those portions that we redacted that were hearsay within hearsay are not read onto the record.
That's fine.
In California, it is illegal to drive with a BAC of 0.08 and illegal for someone younger than 21 to drive with a BAC of 0.01. Based on all of this, I determined to a reasonable degree of professional certainty that the cause of this accident was driving under the influence of alcohol. And with that, Your Honor, we rest our case in chief.
Okay. Anything from the defense? Do you wish to call any witnesses in this trial?
Of course, Your Honor, at this time we call Sunny Meadow.
You can proceed.
Yes, Your Honor. Good afternoon, Miss Meadow.
Good afternoon.
I want to get right into it. Where were you on March 24th, 2019?
I was at my bar that I own, Sunny's Rooftop Bar.
Do you recall seeing a woman named Jessica Marks that night?
I now know her name to be Jessica Marks. Yes, I saw her and her friend Morgan Levin.
I want to talk about your bar, Do you have exhibits 8 and 9 in your virtual exhibit notebook?
Yes, I do.
And what are these?
These are pictures of my bar, the rooftop, which was our greatest attraction.
Are they fair and accurate?
Yes, they are.
Your Honor, we move these into evidence.
Any objections?
Without objection.
They're admitted. Can you repeat the numbers for me, Mr. Wright?
Yes, Your Honor, exhibits 8 and 9.
Thank you.
Ms. Mehta, when they arrived, did Miss Marks appear intoxicated?
No, not at all. If she was, and as rude as this sounds, I would have told her, "You need to go, I can't serve you."
Can you tell the jury what signs you look for when you're trying to determine if someone looks intoxicated at your bar?
Of course. Well, before I even became a bar owner, I had to take the responsible beverage service course, which taught me a bunch of symptoms that we need to recognize, how alcohol affects the body, and then, of course, my experience as a bar owner.
What would you do if you saw someone intoxicated at your bar?
I would first take their drink away, not serve them anymore. Then I would take their keys away too and call them a cab so they could go home and get some rest.
Your Honor, at this time, we're going to display one more portion of Exhibit 26 that we wish to admit into evidence and read onto the record. Mr. Wright, can we get that up?
Any objections, Mr. Mueller?
No objections.
Okay.
Question: if you thought Jessica was unfit to drive, would you have said something either to her or to a bar employee? Maybe. Answer maybe. Yeah, I probably would have. Now, Ms. Mehta, I want to talk about your interactions with Miss Marks that night. Did you serve her table?
I did, yes.
How many times did you interact with Jessica Marks?
It was about 8 to 10 times, I want to say.
About how much time would you spend with Miss Marks during these 8 to 10 interactions?
Oh, 30 seconds, maybe a minute at the most.
During these 8 to 10 interactions, did Miss Marks appear intoxicated?
No, she didn't. When I walk to people's tables, I don't just serve them their drink and walk away. I look to see how they are, and Jessica was fine.
Ms. Mehta, were you present in trial today when Miss Levin testified?
Yes, I was present.
Did you hear Miss Levin describe an event where Jessica Marks stumbled down some stairs into you?
I did hear that.
Did that ever happen?
No, it didn't. I watch my customers as they're coming down the stairs, not in a creepy way, but it tells me whether or not they're intoxicated. Jessica never fell down the stairs.
Was Miss Marks's table the only table you were serving that night?
Oh, definitely not. We had like 12, 14 other customers there. It was a lot of people.
Well, did you have another server helping you serve those 12 individuals at any given time?
No, we were short-staffed. It was me serving all of them, and then Frankfurt Johnson just at the bar.
Did you hear on Miss Levin's direct describe an event where you looked at her, pointed at Miss Marks and said, "I hope this one's not driving"?
Yeah, I heard that.
Did that ever happen?
Not in the way Miss Levin described it. It was actually the other way. I turned to Jessica, who was sober, and I asked about Morgan Levin, that this one's not driving.
Let's talk about Morgan Levin. Did Morgan Levin display any signs of intoxication?
She did. As I saw her that night, she started looking a little sleepy. Her eyes were bloodshot, and I was like, okay, she's starting to get buzzed.
Now, Miss Mehta, at the end of the night, did you watch Jessica Marks and Morgan Levin go down the stairs and leave your bar?
I did. Like I said, it's a good indication of whether or not somebody's had too much to drink or they're intoxicated.
Now, at that time, Did Miss Marks appear intoxicated?
No, she didn't. Not only did she walk down the stairs perfectly fine, but she didn't show any other symptoms of intoxication.
Did she slur her words at all?
She did not.
Did you ever have any signs from Jessica Marks that she needed to be cut off?
I didn't. In all my years as a bartender and from the training course, I know what to look for. Slurred words, bloodshot eyes, falling down the stairs, passing out. Jessica didn't do any of these things.
Thank you, Miss Mehta. No further questions, Your Honor.
Cross.
Yes, Your Honor. Good afternoon, Miss Mehta.
Good afternoon.
Miss Mehta, it's your claim that Jessica Marks never looked intoxicated when you served her, right?
That's right, and I'd be more than happy to explain to you why that is.
It's your claim to this jury that she didn't look intoxicated when she left your bar.
Like I just said, yeah, she didn't present any symptoms of intoxication.
In fact, it's your claim that Jessica Marks looked just as sober walking out of your bar as she did when she walked in, right?
I'm not saying that she was 100% sober. She wasn't intoxicated.
Well, you said she was sober when she left the bar.
She was sober. She was fine, not intoxicated.
Let's explore those claims. Now, you served Jessica Marks's table for almost 3 hours, right?
Yeah, they came in at 9 and left at 11:45, so more like 2 hours and 45 minutes.
You served 2 beers,
Yes, the IPAs are watered down beers.
2 shots,
Yes,
3 cans of hard seltzer,
yes, the White Claws.
and an entire bottle of wine.
Yes, that's how you order them, a bottle of wine.
Miss Marks, she ordered half of those drinks, right?
I believe it was around half, but to clarify, the bottle of wine doesn't count as a drink itself. It's the wine.
So that's a yes. She ordered half the drinks.
Yes, like I told you, about half.
And you heard Miss Levin say that she had more than half, right?
I did hear her say that, but like I told you, I think it was around half.
So it's your claim to this jury that after serving all those drinks, Jessica Marks looked completely sober walking out of your bar?
Yes, because everyone handles their alcohol differently. Depends on the person, their genetics, a whole bunch of factors that the training course taught us.
Well, let's talk about whether there's evidence that she wasn't sober by the end of the night. You know what blood alcohol content, or BAC, is, right?
Yes, I do know that.
It's a measurement of how much alcohol a person has in their system.
That's true.
Your Honor, let the record reflect we're displaying Exhibit 22. It's already in evidence. Ms. Mehta, you know that Ms. Marks's BAC was tested after the crash, right?
Yes, I know that.
You know that her BAC was 0.16.
I do know that. And like I told you before, everyone handles their alcohol differently. Everyone shows it differently.
0.16, that's double the legal limit for an adult?
I believe so, yes.
16 times the legal limit for a minor.
That's what it is, yes.
Finally, Ms. Mehta, I want to circle back to your claim that Jessica Marks looked sober walking out of your bar. Could you please open your exhibit book to Exhibit 20? And let me know when you get there.
I'm there.
Exhibit 20 is a map of the area outside your bar.
That's right.
It looks fair and accurate.
It does.
The plaintiff offers Exhibit 20.
No objections, Your Honor.
Admitted.
Mr. McGaugh, can we get Exhibit 20? Ms. Mehta, you see on the left side of the map, that purple marker, right?
I do.
That's your bar.
It is.
You see on the right side of the map, the yellow marker.
I do see that.
You know, that's where Miss Marks crashed.
Unfortunately, yes, that's where she crashed.
I want to be very clear here, Miss Mehta. Jessica Marks crashed on the road just outside of your bar, right?
Yeah, off the Pacific Coast Highway, unfortunately, in a ravine, yes.
Jessica Marks crashed the night that you served her alcohol over a period of 3 hours.
That was the night she unfortunately crashed.
Jessica Marks crashed, driving home from your bar. Isn't that true?
She did.
Thank you, Ms. Mehta. No further questions.
Mr. Wright?
Yes, Your Honor. Ms. Mehta, opposing counsel asked you a couple questions I want to talk about. First of all, he asked you if at any point that night she didn't appear completely sober, and he was comparing it to when she got there and when she left. From what you saw when Jessica Marks left your bar, she appeared drunk?
No, she did not. And like I've said before, if she did, she would not have her keys. She would not have left in her car.
Between her and Morgan Levin, which one appeared to have more signs of intoxication?
Morgan Levin. Morgan Levin was the one with bloodshot eyes. Morgan Levin was the one that looked sleepy, not Jessica.
Thank you, Ms. Mehta. Nothing further, Your Honor.
Anything else for this witness, Mr. Mueller?
No, Your Honor.
Thank you very much, Ms. Mehta. You can step down. Mr. Wright, do you have any additional evidence before you close your case?
No additional evidence, Your Honor. At this time, the defense rests.
Thank you, counsel. Anything we need to take up before closing arguments?
Nothing from the plaintiff, Your Honor.
Okay.
Nothing for the defense, Your Honor.
All right. We're going to proceed to those momentarily. I'll tell you that you're permitted to share on screen any exhibits that have been admitted, the jury instructions, the jury verdict form, any demonstrative evidence that doesn't include facts that is limited to facts that came out in trial. Understood?
Yes, Your Honor.
Yes,
Okay.
Your Honor.
And you'll work off of the time signals in the chat from your second chair. I'm assuming your second chairs have been in communication all trial. Mr. Mueller, you go first.
May it please the court, members of the jury. They knew she was drunk, but they kept serving drinks. 16 times the legal limit. On March 24th, 2019, when Jessica Marks left the defendant's bar, the amount of alcohol in her system was 16 times the legal limit for her age. 16 times. And the defense, they tried to tell you Jessica Marks just didn't look intoxicated at any point that night. Members of the jury, a 19-year-old girl who was at the defendant's bar for as long as Miss Marks was, who was served as many drinks as she was, who had a blood alcohol content of 16 times the legal limit, is going to look drunk, whether they deny it or not. They knew she was drunk, but they kept serving drinks. Of course, we couldn't just tell you that. We had to prove it. We had to prove our claim of wrongful death by a preponderance of the evidence, meaning more likely than not. Almost everything we had to prove went undisputed. There's no dispute that Jessica Marks was a minor, and there's no dispute that the cause of her accident was driving under the influence of alcohol. The only question today is whether or not she was obviously intoxicated when the bartenders served her. We've proven that she was. We've proven that she was by proving 3 simple facts. Fact number 1, Jessica Marks was intoxicated at the defendant's bar. We called Morgan Levin to the stand, a friend of Jessica's that was with her that night. She told us that the whole time they were at the bar, Ms. Marks had all the classic signs of intoxication. Bloodshot eyes, slurred speech. She was stumbling around. But you didn't just have to take her word for it. We showed you this video that was taken of Ms. Marks that night. Members of the jury, this video is absolutely crucial to our understanding of this case. This case, it's about how Ms. Marks was acting at the bar. Was she drunk or was she sober? We don't have to guess about how she was acting. We don't have to speculate because we literally have a video from that night. We can see for ourselves how she was acting. We can see for ourselves that she was obviously intoxicated. And that brings us to fact number 2. The defendant saw that Jessica Marks was intoxicated. Now, Sunny Mehta, the bar owner, took the stand and she swore up and down that even after serving 2 shots, 2 beers, 3 cans of hard seltzer, and an entire bottle of wine, Jessica Marks looked completely sober walking out of the bar. But we know that's not true. We know it's not true because of Ms. Mehta's own words. We might need to cut this one off. Those aren't the words of a bartender that didn't know their customer was drunk. They're the words of a bartender that knew, but just didn't do anything about it. And that brings us to fact number 3. Despite knowing that Jessica Marks was drunk, the defendant kept serving her drinks. First off, we acknowledge that the defense is saying they just didn't see signs of intoxication. But here's where it's so important to understand our burden of proof. We don't have to show you a confession from the bartenders that they knew, because they're never going to admit that they overserved a minor. We just have to prove it's more likely true than not that they did. What's more likely? That after having all those drinks, after seeing how she was acting with a blood alcohol content of 16 times the legal limit, she didn't look drunk? Or is it more likely that she did? Members of the jury, I'll submit to you that it's far more likely she would have looked drunk. This is the jury verdict form. Because we've proven those 3 facts, for question 1, which asks if we've met our burden of proof, you can check the box for yes. Members of the jury, what makes this case so tragic, it isn't just what happened to Ms. Marks that night. It's how easily the defendant could have stopped it. All they had to do was stop serving Ms. Marks the second she started showing signs of intoxication, but they didn't. They knew she was drunk. They kept serving drinks, and that caused her to crash. Find the blind. Thank you.
Thank you, counsel. Before we hear from the defense, can we find out how much time is remaining for Mr. Mueller's rebuttal? Timekeepers can let me know in the chat. 55 seconds remaining. Both parties are aware. Mr. Wright, you may proceed.
Yes, Your Honor. Sonny's bar only saw what Jessica wanted them to see. Jessica Marks, she's standing at the top of the stairs, Sunny's rooftop bar. As Miss Marks descends those stairs, she doesn't trip. She doesn't stumble. She looks over to the bartender and says goodnight. She's not loud. She doesn't slur her words. Members of the jury, that's how Jessica Marks was acting when she was in front of Sunny's staff. And that's undisputed evidence. It's something the plaintiff's own witness told you. She didn't stumble out to the parking lot. She didn't trip when she was going down the stairs to leave. That's a problem for the plaintiff. And today you learned why. See, I asked Morgan Levin on the stand to tell you all how many bars that week they went to. How many bars that week Jessica Marks drove from. And what did she tell you? She said a few. But then you learned there was actually 6 bars that week. We'll get to why that's a problem for the plaintiff's case in a second. Before we do, let's talk about what that means. It all started days before Jessica Marks ever came to Sunny's rooftop bar. Jessica Marks visits her best friend. They bring the fake IDs. For 6 days, Jessica goes bar to bar throughout LA, using those IDs, visiting 8 different bars that week, and Jessica drives under the influence 5 times. That's how Jessica got so familiar with staying in bars past her legal limit. That's how Jessica was able to show the bartenders at Sunny's rooftop bar what she wanted them to see. Now, the plaintiff, they had to prove to you that Sunny knew and saw that Jessica Marks was intoxicated, and then made that conscious decision to serve her more drinks. That's just not possible, members of the jury. Jessica never displayed a single sign of intoxication, not just to Miss Mehta, but to anyone at the bar that night. The only person that displayed any signs of intoxication was their witness. Their witness can't be trusted. The reason she can't be trusted, well, it's not just because she was the best friend of Jessica Marks. And it's not just because the same attorneys that directed her today were going to sue her. And it's not just because she's contradicted by everyone at the bar that night. It's not just because she was the only eyewitness the plaintiff could find. It's because she was drunk that night. It's because multiple eyewitnesses testified that she was the one with slurred speech. She was the one with bloodshot eyes. She was the one with a lack of balance. She could hardly walk to her Uber that night. And that's the plaintiff's only witness. So what evidence did they actually bring? Because right now you've seen a video and a receipt. So let's take those. That video. The plaintiff, they didn't say a word about where that video went. He certainly didn't mention the fact that Jessica was in front of a camera. Of course she's going to act drunk. That video was for social media. Of course she's going to appear as intoxicated as she can. It's the last day of spring break, posting it on Instagram. But what you learned today is that Morgan Levin didn't show that video to Sunny Mehta. Sunny Mehta never saw that video. Sunny Mehta never saw Jessica acting the way she did in that video. What about that receipt? That receipt, it doesn't tell you a single thing about when these drinks were bought, who ordered the drinks. It doesn't tell you who finished the drinks. The receipt you saw today tells you that Morgan Levin signed the bottle. And we can see the signs of her intoxication on the plaintiff's receipt. And today you learned that Sunny's rooftop bar, it has 2 levels, exhibits 8 and 9. And Mr. Wright, can we get exhibits 8 and 9 on the screen? Today, Ms. Mehta told you that that bar has 2 levels, and she said that Jessica was upstairs. Well, the bar itself was downstairs. Sonny Mehta spent the entire night running up and down those stairs, taking orders, delivering drinks. She spent maybe seconds at each table. Never once saw those signs of intoxication. And neither did anyone else. No one tried to take her keys. No one tried to call her a cab from the bar. The only person that says they did was Miss Levin, who you can't trust. Not even Stevie Reggers tried to call an Uber. And today you learned Stevie Reggers made a deposition in this case. He was just a guy at the bar that night. He's another eyewitness that told you Jessica Marks appeared perfectly okay to drive. Stevie Reggers, he didn't have a lawsuit. He didn't have a reason to make something up before you today. You learned that he watched Jessica's table the whole night. Jessica seemed perfectly okay to drive. That's evidence that everyone in the bar only saw what Jessica wanted them to see. The death of Jessica Marks, it's a tragedy. We all want someone to blame, but sometimes we're presented with cases like this one. The person we look to for answers is no longer with us. One thing's for sure, Sonny's bar only saw what Jessica wanted them to see. That's why we ask you to find Sonny's bar not liable.
Thank you, counsel. Mr. Mueller?
Yes, Your Honor. They only saw what she wanted them to see. That's what the defense has said over and over again throughout today's trial. But it just doesn't make sense. A person who was served as many drinks as Miss Marks was, who had a BAC as high as Miss Marks was, who was stumbling around the bar, slurring her speech, can't just turn that off on command. Members of the jury, we know how she was acting. We saw that video. She was drunk, and they knew it. Find them liable.
The matter will be submitted to the jury. I'm going to ask our jurors to now submit their ballots. If anybody needs the link, again, let me know and I can send it to you in the chat, but I think you should all have the link to your ballot. In the meantime, I'll say congratulations to both of our attorneys and to both of our witnesses. Outstanding job. Let's give them a round of applause. We'll do some comments and feedback for our competitors right after we have the ballots submitted. So hold tight.